generally, and the challenges that are emerging for US litigation. Do you want to make a few general comments about this changing landscape?
Sure. This landscape is changing quite quickly, and it becomes very difficult for U.S. litigants, I think, to have to educate a lot of the courts and the judges here that are presiding over our discovery disputes about what that means for traditional discovery and what the consequences are for mishandling European personal information. And I think people are experiencing that firsthand, and I'm working on a number of litigations at the moment that involve U.S. data or U.S. matters that are seeking EU data, and it's a fine line to walk to have to explain that your average litigation hold, which is it's standard even for a matter that hasn't proceeded to a live complaint yet, that even processing someone's personal data, such as their name, if you're an EU resident, is considered processing subject to the GDPR. That's just oftentimes a concept that is so foreign to litigants and to judges presiding over those matters that it's quite an uphill road to climb. But the Sedona conference has some fantastic materials on this that I would highly recommend people read, that walks folks through how to go about identifying the issues and raising them with the court, and kind of teaching your opponents and where you have to. It's obviously the best case scenario where you have two large multinational corporations with skin in the game, so to speak, that are both handling EU information, but where you have more of a one-sided power distribution, where you have a plaintiff that's a small individual demanding corporate information of multiple custodians across the globe. That's when you really sometimes have to go to the court and educate them about why you're not being obstreperous necessarily for not just dumping enormous amounts of data, personal information in discovery, but that there are careful steps that you have to take, and that you're navigating multiple jurisdictional rules here.
So, Karen, the underlying theme to what you've just outlined, I think, is that we're really often talking about a conflict of law scenario, potentially, aren't we? It's sort of dangerous territory for litigators and even their clients. Does it come down to sometimes, which law do I break? Do I maintain compliance with a court order in the US in relation to discovery obligations, or do I run the risk of violating a GDPR provision? How do you advise a client when they're delicately balancing that scenario?
Well, of course, it's case specific on how sensitive is the data. If it doesn't relate to individuals at all, you're in a better situation, obviously. But if it's highly sensitive, if you're a bank, you're dealing with financial information. If you're a life sciences company and you have people's health information, and even if you're a company that you're just producing correspondence of employees, you may have sensitive subjects like that come up around what are considered special categories of data under Article 9 of the GDPR, which is racial background or sexual orientation or even political views and trade union membership. These are all categories of information that should receive extra protection, and oftentimes there's no real way to find that without reviewing it. So there are a number of practical steps that you can take, but before I get into the nitty-gritty of those, the goal here really is to stay on the good side, right, of regulators on the one hand, and of your the court in which you're practicing on the other in the United States. So in a traditional U.S. litigation, where data privacy of EU citizens is not an issue, the relevant standard is really quite broad. But where you end up having the information of individuals, the names, their contact information, and other such details swept into the realm of discovery of a U.S. case, you really have to, that's when it's considered processing and, under the GDPR, and you take certain, I'm sorry, there's some shuffling noises on the phone.
Yeah, I can't quite work out what that is. I'm sorry. Jonathan might have joined us. Are you?
I have joined, but I didn't want to spoil the flow. Sorry, technical issues prevented me from joining.
No problem. Are you the shuffler? Are you the shuffler there?
No, I unmuted and very deliberately did not shuffle a single thing.
No problem. We'll sorry everyone. Let's keep rolling. Karen, you were in the middle of making a very good point there.
Right. And so, I mean, data privacy officers make this kind of pragmatic call all the time, because the reality is that there is a bit of a conflict, right? The broad discovery obligations in the U.S. just aren't incompatible fundamentally with protecting privacy interests of European citizens. And in fact, whenever you do process information of EU citizens, say as an employee, you have to have a lawful basis for doing so, either under contract or you have to have their express consent. So when you have, if you're a corporation and you have a number of employees, when you, the best practice would be to issue them information notice when they first join the company, saying, look, these are the kinds of data elements we collect. We collect your name, we collect your address, we collect health information to the extent that we have to administer benefits. We do a background check on you if that's something to do, and here's why. So you have to tell them what you're collecting, why you're doing it, and the purposes for which you do it, whether it's pursuant to the employment contract. But in the information notice, we would advise all of our clients to make sure that you put the possibility of litigation in there, because that's just something that is a possibility always, right, in today's society. And you want to reserve that future possibility. And so that protects you from kind of a information and employment perspective.
There's a real cultural scenario there, though, Karen, do you think, in that, and Jonathan, I think you mentioned this when we were talking about it yesterday, the cultural tendency for example, UK citizens to not be inclined to pursue these sorts of things with their former employers or their current employers, whereas in the EU, it's very common for data subjects to really get quite vigorously protective of their privacy rights. I don't really know where US citizens sit in that spectrum, but I suspect that the awareness is increasing. And I wonder what your thoughts are on this, Jonathan. How real do you think this emerging trend is in the UK?
But in terms of asking to see your personal information?
Well, I guess, we'll referring to DSARs, for example, data subject access requests, maybe you could talk a little bit about what is a data subject access request and what are the cultural differences between the UK and the EU in relation to them.
Well, a DSAR, a data subject access request under the GDPR, and I'm sure Karen will nicely correct me if I get the law of this wrong, because I'm not a lawyer, is the right of every individual to ask of those who hold information about them on a consent basis or on a whatever understanding that basis is, to provide to them all the information that they hold, so that the individual concerned can obviously see what information is being held about them and can choose various options, such as having it all deleted or having it all anonymized or pseudonymized. So that they are in control of the private information that they have decided and elected and chosen to share with that organization or other individuals. Now, the time within which these requests must be complied with is not very long. It's about 40 days, isn't it, Karen?
It's 30, but you can also ask within the first 30 days for an extension, but then after that, you only have another 30 days maximum. So
Okay.
in total.
Thank you. And there used to be a nominal charge under the original Data Protection Act, but now it's a free request. And the cultural take that Jo is referring to is that in the UK, we don't tend to have a culture of questioning our employers very much. We tend to like to muddle along quite nicely and asking difficult questions of your employers. This may just be a generational thing, by the way. Asking difficult questions of your employers and blocking the boat attack is not an acceptable thing to do. However, in many continental Europe countries, it is perfectly acceptable and a prevalent thing to do under the GDPR to start asking difficult questions about personal information, because continental Europe, I think, regards its personal information as more of the crown jewels than we in the UK do. And I think probably considerably more than people in the US would. So I would imagine that continental Europe to UK to America is a downshifting spiral of interest in the importance of PII. But the GDPR is a European regulation set up to govern the rights of European citizens or residents to have control of their information, where it goes, who uses it, and for what purposes it is used.
So Karen, do you think that this trend towards seeking access to your private information that is held by others is going to lead to looming class actions and increased litigation activity in the US as frameworks like the Californian privacy legislation start to get implemented?
We've seen, and I think leading up to the GDPR, there were kind of a horror story, worst case scenarios like Y2K, if you will, that era of, the day that it goes live, there's going to be all of these subject access requests. This is the new kind of MDL or class action of the EU. But the reality is that only the biggest targets, like Facebook or Google, have been targeted for those access requests. And they rolled out around May 25th when it went live, but we haven't really seen that yet, knock on wood, to affect the majority of companies.
Okay.
Is that,
However,
Jo, is that because the regulators just are as unready for this as the European organizations and citizens are?
Yeah, we're hearing from regulators that they're trying to still get their instructional guidance materials in place to answer the questions that have already been proffered to them, because as everyone understands, the consequences now are for liability and fines are much higher, and so everyone has a number of questions for the regulators, who have set up these really helpful channels of communications with them, but they are now underwater with dealing with those questions and also for looking into the requests from daily citizens and everyday folk trying to get clarity as well. And there have not been that many high-profile GDPR actions since it was enacted, although we are seeing a few.
So given the uncertainty that is prevailing in relation to the extent to which the privacy framework is going to be regulated and enforced even by the regulators, what are some practical steps that those involved in US litigation can take to make sure that they mitigate the risk that they and their clients are facing? We discussed when we prepared for this a day or two ago some of our experience-based recommendations, and I'd like to sort of open the discussion to either of you to sort of suggest a couple of these strategies. Jonathan, do you want to sort of kick it off by maybe highlighting a couple of things that you'd recommend that people might do?
Okay, thank you. I think one of the most important things that you can do is involve the necessary authorities in the jurisdiction / countries in which you need to conduct your discovery or get your data. So that would be the data protection, data privacy officers in your client's offices or wherever it is that you need to collect this data, where possible or sensible or feasible, if there is such a thing, to talk to the regulator in that jurisdiction to make sure that A, they are aware that there is a multi-jurisdiction dispute that is going to be happening on their soil, on their territory, and B, that they can have the assurance that you are listening to their advice as to how best to proceed so as not to fall foul of that regulation. I think that, like in the old days, under data protection, it was a vital thing to involve works councils and other bodies of organisations that looked after people's individual privacy and rights. Karen?
Yes, I agree, although we should also keep in mind that where you do contact a regulator, where you receive that advice, obviously you have to comply with it, right? So there's always that forgiveness or permission kind of dichotomy to consider before you open that door. And what we do suggest is, as Jonathan mentioned, the first part obviously is knowing what jurisdictions you're subject to, because over and above the GDPR, there is a framework. Say if you're in Germany, even there's national state laws that apply, and then depending on the jurisdiction in which that your employees reside, are you in Bavaria, are you in Hesse, or are you in even those particular regions within Germany have their own data protection local laws that you have to follow. So it's making sure you have the right experts in the room to help navigate those minefields. But to kind of rewind, before litigation even hits, I think, again, those information notices that I mentioned are part of having good hygiene practices in place to begin with. There are a lot of companies out there that are retaining a lot of obsolete information that they don't have to, that contains personal information, that's not subject to any business requirement, it's not subject to any regulatory retention requirements, and it's just excess information that once a discovery demand hits, once it's subject to legal hold, you cannot delete. So having your house in order before litigation hits and in between those holds is very crucial. So having timely deletion and compliance with retention policies, and also an electronic communications or acceptable use policy that informs employees that, that you probably shouldn't commingle your personal data. You probably shouldn't talk about the affairs you're having or send each other, inappropriate things or make reference to non-business information. You shouldn't save it in your files or email it with your business account, because it could well be collected in some unrelated litigation, and we don't want to intrude on your privacy, and for you to minimize that risk, just be very careful with what you're putting into your business accounts and your business storage areas.
So really effective information governance policies and practices help to put the right framework in place to provide some protection potentially, Karen.
That's right.
I mean, I've said before that information governance is the kick up the back. GDPR, is the kick up the backside that information governance needs. It's so much everyone's friend in these scenarios and so many other scenarios that it's making even less sense not to have an information governance policy in place for a multinational.
And you've both made reference to the corporate DPO, that we're increasingly seeing data protection officers as a senior level executive role in the client organisations we're working with. Presumably they would be key to involving as early as possible if there is any litigation that requires data from EU citizens or from that could have a privacy impact. So is that effectively what you were mentioning there?
Yes, if such a person exists in that jurisdiction, which is a big if at the moment in my experience. What I do find though is people listening will think that there must be fantastic delays concomitant on involving any European country in your litigation or data from any European country. What service providers are increasingly doing is being as safe as they can and using people, nationals of that country, in that jurisdiction, to collect the data in that jurisdiction, to process the data in that jurisdiction, to review that data in that jurisdiction, so that they are using the time fruitfully whilst all these conversations are going on and advice is being sought, if it is so sought, and are doing their own sort of mini information governance, I suppose, and reducing the amount of data that leaves to just that which is responsive with minimal personal information in it and with minimal non-responsive or potentially irrelevant documents that did not need to be moved out of the jurisdiction.
Right. So collecting, obviously collection locally, but also processing and potentially even first pass review locally, either in situ within the corporation or at least in country. So we're sort of avoiding the problem altogether.
And that's why I think we're seeing the consolidation of the large service providers like Concilio, who have gone down the route of global domination because they can see that they need to be effective in all these different jurisdictions. Right.
Karen, I think you had a view on this which is related, and that is you were mentioning the concept of the scope of the collection and the scope of the discovery process. Do you want to elaborate on that a little bit?
Sure. Before launching into that, what you're going at in terms of data, cross-border data transfers is the GDPR mandates minimization where you can. So if you don't need to dump massive quantities of personal data across borders to a country that is, like the US, not considered to have adequate protections unless using the privacy shield or BCRs or other adequacy mechanisms, then when you're transferring data cross-border, you want to make sure it has been honed down to the smallest amount possible, which ties back to my earlier point about the US standard for relevancy and the EU standard, which requires probity. So it can't just be relevant to the case. It has to be relevant and probative to a disputed issue in the case in order for it to rise to the level of something important enough to cross that border. So if it's just an email that is relevant but not necessarily helpful to determining an issue and dispute, it should not go over. So when you're looking at your collection at every stage, when you're preserving, when you're collecting, when you're reviewing, and certainly when you're transferring over to the US to that case team, you want to try and cut down the volume as much as possible. Because, again, the standards are just different.
It's a much more stringent test, obviously, relevant and probative as opposed to potentially relevant.
Absolutely. And to that end, if you have a US server that contains the same kind of information, the same documents, and you don't have to go into the EU and gather that data and then make that transfer, then that's what we would recommend doing in the first instance.
Right. And just to go back to one of the very basic sort of questions, we might have sort of skipped over this right at the beginning. I think we've just had a question posed by one of our webinar attendees. Just to clarify, the question is, does this apply to US citizens or to data that's collected from US servers? I think that the issue is that, how do we tell which data belongs to an EU citizen and which data belongs to US citizens? I mean, we often don't have that information, do we? Karen or Jonathan, do you want to comment on that? It seems like it's very confusing and it's quite murky.
Well, in terms, if I may, Karen, in terms of to whom it applies, to whose data it applies to the data of any European resident or citizen, certainly citizen. wherever in the world that data is and wherever in the world that citizen is at that point in time. It doesn't apply to American citizens who've been in America their whole lives and have never done any dealings with Europe. It's all to do with European citizens. As to that thorny question of how you identify whether an individual in your discovery is a European citizen is one of those questions that tend to get swept under the carpet at the moment because it is too enormous a question or implies too much of a task to identify that person.
Too difficult, isn't it?
Yes.
And then there's
in the same way that it's nigh on, it's not impossible, but it's impractical to attempt to get consent from every single person whose personal information is in the discovery that is being conducted, or indeed in the data that's being collected. So every email address you see there, you cannot really contact that person who may not anymore be at that email address and ask them if they mind if you give that printed email or that electronic email over to Smith and Blogs.
Sure. So obtaining consent is not practically going to work, but even the fact that consent can be withdrawn presents problems. So even if you were to get it, I think, Karen, you were mentioning earlier that consent can be withdrawn, or it can actually even be null and void if you have an employer or employee relationship.
That's right. Most regulators in the EU take the position that where you have an employment relationship, in that context, the consent by the employee is presumptively void because of the power inequality inherent in the employer-employee relationship. Therefore, consents are not practical from that standpoint, but really, moreover, employee or not, where you have a consent, and that's what what you're relying on. Under the GDPR, consent is at a later stage, revocable, modifiable, so that I give my consent for my data, and right now, at the moment, I am resident in the EU. I can later contact that lawyer a year from now and say, look, I changed my mind. I've thought about it. It doesn't make me feel good. I've been reading all of these news articles about data breaches, and the fact that it's going over to the US, don't like that. I'm clawing it back. Well, right. In the litigation, you could have, the lawyers in the case could have already exchanged that with each other. They could have a blown up exhibit with my name on it, ready to go to trial, and it's already been produced, 50 times over. So consent, honestly, from a practical standpoint, in this context of litigation, is not really practically workable. So we would recommend notice, but not necessarily consent.
Sure. So back to those practical steps that can be taken. We've discussed a few. We've talked about good practices in terms of information governance. We've talked about involving the data protection officer, if there is one in the corporation, potentially if it is strategically beneficial to do so, and it may not always make sense, but potentially even talking to the regulator. Karen, you mentioned earlier the potential to obtain a court order in relation to the discovery process, so that you can at least show the regulator that there is a court order in place. Not that they will respect it necessarily, but at least there is a court order there. Do you want to elaborate on that a little bit? I think we might have glossed over that a little bit. And have I even summarised it properly?
Well, I think that the court order I'm referring to here is, well, there's two things, right? One court order is the court order that says, look, you really do have to produce. I don't know what the GDPR is. I don't really care. You've been told this is your discovery obligations. Don't shirk them. That is your future defense when you have in your back pocket if you are ever later then subject to regulatory scrutiny. But the court order that is the most important, in my opinion, when you're working in a U.S. court of law with EU citizen data is a protective order to make it as restrictive as possible. Again, to minimize the amount of data and also the dissemination of that data. So where you have employee data or EU data that is being processed by vendors like EDT, that there's a confidentiality order in place. And with the court order, you say it's attorney's eyes only. Other court orders that can be helpful are phase discovery timeline plans. And if you have, again, an opponent that is a corporation or some other entity that is also handling EU data, you guys can both work together cooperatively to set standards for what, you're going to, how you're going to approach those data privacy issues. Like an en banc review, for example, for sensitive documents might be something that you aim to do. But it's best, obviously, to have an opponent with skin in the game who will meet you with the same concern.
Sure. Jonathan, did you want to comment on that at all?
Yeah, I think that it's always good to demonstrate progress to the US courts if you can conduct rolling discovery whilst you're having your conversations about privacy. But I think also there is, in this day and age, it's fairly recent in the US, the proportionality rule. If you could show to the US courts that it would be disproportionate for you to find and preserve and collect and so on and so forth European data, if the return on investment, if the value of that evidence isn't necessarily worth that effort, that could be a way of avoiding the entire Pandora's box. Right,
that's a good point. And the concept of narrowing the scope of the collection is something that I think we touched on earlier, but to elaborate on that a little bit, Jonathan, do you think it's practical at times to obtain the data from other sources or think creatively about how we prove or disprove the allegations using other evidence or other sources? Is that a valid strategy here?
Yes. I mean, especially if you're a US corporation with subsidiaries in continental Europe, it's entirely possible that you will have backup systems in the US back at the mothership that could hold that data. What you then choose to do with it and with your lawyers is entirely up to you, but it's not actually physically at that point in time coming out of Europe. I think that, obviously there are two trains of thought in terms of doing a more surgical strike in terms of data collection. There are the school of thought that says that a surgical strike is minimal impact on the business at that point. But if you get it wrong, you've got to go back and disrupt the business and perhaps deal with data that's moved and that kind of thing. So many people tend to go and do a wide collection, such as the whole email server, rather than specific custodians on that server. I think those kind of choices aren't necessarily available anymore whilst working with European jurisdictions. I think that, as Karen said earlier on, the more that you can do to minimize the problem will actually minimize the problem. Right.
And I think there was reference earlier, Karen, to the Sedona conference. You mentioned there's some principles there. Can you refer to, what's the reference there that for those that are listening to the model transfer protocol, I think it was that you mentioned? Can you give us more information about that?
Sure. The Sedona conference has they issued these international principles on data, on discovery and data protection. They're called it's a long title, but if you want to write it down, it's International Principles on eDiscovery, Disclosure and Data Protection, Best Practices, Recommendations, and Principles for Addressing the Preservation and Discovery of Protected Data in U.S. Litigation, which is it sounds like it was written by lawyers. It's a really long title. And what it does is it incorporates 11 compliance steps that can serve as your record to the regulator. If you're looking for a protection order, there's a model protection order provided in this document, a transfer protocol, a data process to follow. And so I think it's a really good resource for those that are seeking the closest thing to kind of a toolkit when they're faced with international litigation issues.
Karen, this is Gail. I just want to ask you a quick question. Is that available on the Sedona website?
It is.
Great.
Free for download. So I would highly recommend those that are interested to seek that out.
Indeed, I can remember about 8 years ago having a very heated debate in DC within the Sedona conference with Judge Irish Einlin about the practicalities of, because this is one of the last grasp ways of trying not to fall foul of the GDPR, of redacting the heck out of everything. it's bad enough trying to identify people to notify them or obtain consent, and we know why that isn't necessarily going to work at all. But trying to redact all the PII in all the discovery could negate the evidential value of that discovery, let alone be a particularly headache of a task to undertake. But it is an option.
Yeah, it is one of the options that's certainly mentioned within the GDPR framework. But I just wonder, in practice, as you suggest, Jonathan, how do we go about anonymizing a disclosure or discovery data set? And the other concept is the word that I always have a problem with.
Pseudonymization would be the word you're hunting for, I'm sure.
Yes, yeah. There's too many syllables in that word.
I think
maybe you could explain what that means, first of all, before talking about how practical that is.
Well, I think that my point here is that if you redacted everything, and if your matter involves what individuals did or did not do, and where or when they did or did not do it, if you can't attribute the individuals to those activities, actions, or whatever, then the evidential value of the data you've collected is zero. Because you can't stand up in court and say, I see, Karen Lust, that on the 3rd of January 1994, you were in Belgium reading this email. Because you won't be able to do that in the new scenario. So there is an alternative, which is pseudonymization, which is, in effect, giving all the people in there and all the information, all the personal information in there, a code, a scrambled code, if you like, and having one table that would now allow authorized people to unencrypt that so they could still see in a secure environment what the individual information is, because and as and when it is pertinent to the matters in dispute, anyone else trying to look at it would not be able to see that information because it would be scrambled. So that's one way of approaching it, but I think that there are no practical solutions for large-scale discovery yet. I think that much like in the 90s when people were talking about electronic discovery and everyone was doing hard copy, the electronic discovery was privately and quietly swept under the carpet by opposing law firms as being too difficult to work with, and they'd find everything they need in the paper. I think we're at the stage now, where everyone knows privacy is really, really important, but nobody knows how to apply it to large data sets. So until the software and the practices come along, they will just quietly ignore it, but be very ready to jump on the solutions and the practical applications as and when they become available. Or, of course, as until the various regulators start imposing their massive fines that they have the potential for imposing.
I think that's what people are fearful of, isn't it? Ultimately, there's some pretty significant fines. I don't think we mentioned at the beginning, we might have sort of skipped over this very important fact.
Because it was my slot to do, and I was late on the call.
It's worth repeating anyway, Jonathan, the fines that can be applied for breaches of the GDPR and other privacy legislation in other jurisdictions too is starting to follow suit. But
the headline figure that everyone talks about, and it is definitely there, this is what gives the GDPR the teeth the Data Protection Act never really had. There are a scale of fines, but essentially the real headline one is that an organisation in breach of the regulation can be fined up to 20 million euros, or up to 4% of the preceding year's annual worldwide turnover. So these are not the kind of figures that a bank will just hand over in a brown envelope. These are the kind of figures that make a global organization think very, very, very hard about their next steps in relation to personally identifiable information.
So it certainly is a matter of balancing out some risks, and I think, Karen, you referred to the notion of just making sure we're informed. I mean, sometimes risks have to be taken, and it's about taking informed risks and doing whatever you can to mitigate exposure.
That's right. You're never going to have perfect compliance, right? And that's what a DPO deals with day in and day out, because you're forced to make these difficult decisions. And the best you can do is take the most common sense steps to minimize data, to protect personal information, and to create a a log of all of these decisions that you've made at every step to limit the dissemination and limit the volume, so that if ever a regulator comes, you have a good record to show them.
Sure. And it
They're
will
not,
just,
because the
sorry.
fines, sorry to interrupt, the fines are really, regulators have said, kind of reserved for the most willful, purposeful, or very careless, reckless acts of handling personal data, not necessarily for where someone has really tried their best, made some reasonable decisions, and really had these, they've gone down and record for themselves, right? So that's the understanding that we've been given.
I think, Joe, if I can just step in there, I think that's a really good, really valuable point, that as long as an eDiscovery professional, as long as you can demonstrate the fact that you are aware of your obligations under the GDPR, and you are conducting yourself in a manner to try and comply with the GDPR, then steam ahead, gently, obviously, and carefully, but as long as, the regulator would look more favorably on you if you are paying attention to it, rather than just steaming in and bagging and tagging everything and running out.
Absolutely, absolutely. So, well, awareness is the first step, though, isn't it? And I certainly feel like there isn't the level of awareness, at least within the US, given that that's where I work now, day in, day out. I just don't see enough litigators and eDiscovery practitioners sort of discussing this issue. And I think it only takes one company to really fall foul of the regulators for us to all really get a wake-up call on this topic. But there is light at the end of the tunnel, as you've suggested. There are some strategies that can be put in place, and it does occur to me that doing projects in situ, in country, on location is a very real and pragmatic step that can be taken. And certainly there are many vendors around that actually provide software or services that help to facilitate that notion of local delivery of a solution in Europe. It will be very interesting to see what happens in California as well, as the privacy protections start to become more prevalent there as well.
And how the other 49 states decide to treat it.
Yes, exactly. But then once it is fully implemented in California, and it might actually already be so, the practical reality is that it's effectively becoming a de facto standard, because it's very difficult for large corporations to separate out data that they're maintaining for European citizens or Californian citizens, or citizens based on geographic location. So I think what will happen is that these new principles are just going to be pervasive no matter where you live. Do either of you have a view on that?
The California law was passed and signed, but it does not become effective until January 1st of 2020. Just in case anyone else is, you have some time to get your privacy policies and stuff in line with the new requirements. However, while I do think that the GDPR level standards of subject access requests, of minimization, of notice, of consent, and having a lawful basis to process information, that is going to definitely be a push that you can't just write off as an EU thing, right? It's Japan, South Korea, a lot of countries honestly have very strict standards. Mexico, Uruguay, for processing data stricter than that in the U.S. And we are playing catch up, and I think it's a matter of time before we do see changes that are not just in California, but in other states as well. However, I would hesitate to say that that's going to change the way we litigate overnight and our discovery obligations, because there's going to be a lot of pushback from attorneys, bar associations, and things like that if we do have those impact each other. And right now, as drafted, the California law expressly carves out the ability to make claims, defend yourself and make claims and things like that from having the privacy, their new privacy law. It's an exemption. that's expressly in law. So I don't know that in the litigation context that we would see that much change overnight.
Right.
Which means, to my mind, that we're going to continue to see rather unfortunate people stuck between Scylla and Charybdis, facing fines and perhaps going to prison for not complying with the one or not complying with the other set of laws.
Mm. Yes, it's challenging times ahead, but at least if we go in with our eyes open and try to remain aware and put in place some of the good practices that you've recommended, we can try to ensure that our clients are well equipped to deal with these challenges. I guess wrapping up on a fairly more upbeat topic, it does occur to me that some of the skills and capabilities that we develop over time within the eDiscovery sector might actually be very highly relevant to these emerging sectors like privacy protection and even cybersecurity. And the interesting pivot for this topic might be to say, well, those of us that have been working in the industry for a long time, do have potentially a bright career path as increasing awareness of privacy and cyber becomes more prevalent. Do you have a view on that?
100% I do. And I look at all these conversations going out in the wider legal community about machine learning and artificial intelligence, and I'm thinking, heck, we've been doing that in ED for years. All the skills, all the software that we use in eDiscovery, or Discovery generally, but eDiscovery specifically, is applicable in so many other sectors and so many other fields of law. It's a bright future for all of us, whatever happens to GDPR.
So if privacy kills eDiscovery, then we can all jump on the new ship, do you think, Jonathan?
Absolutely. I mean, just look at the Panama Papers and the Paradise Papers at the very least. They were both broken out. All the facts were broken out using eDiscovery processing software, Nuix. I mean, it's
yeah, absolutely. And we've certainly been doing a lot of work in that area as well at EDT. It's been quite exciting to actually pivot some of the established tools and capabilities that we've built up over a long period of time to provide PII detection capabilities and to move into these brave new territories. So it's not all doom and gloom ahead. But do you have any final comments as we wrap up the webinar? Karen, is there anything else you think we might have skipped over that you'd like to leave with by way of a passing comment at the end?
Just to keep all the GDPR principles in mind, even if you take these common sense steps, because that's going to guide you and your instincts. One other thing that I did want to mention that I think as an American now living in Europe and is the fundamental difference. If you can take this, it'll inform perspectives going forward and applying it in your daily practice. That in the U.S. Information, this is why we don't have adequacy. There's lots of breaches, but when I have my data collected, it was something that I had in my business emails, policy for litigation. You kind of think, oh, well, that's what's just that's. They have my information and they're using it for their purposes. In the EU, the perspective is very much my name and my information is mine. I'm going to let you have it, but only for this limited purposes, to process my paycheck, to give you my benefits, but that's it. I did not consent for you to do anything else with it. And it is my fundamental human right, the way we have free speech in the States. They see their information in an ownership light that Americans may or may not understand. And so when you see it that way, then you understand the importance behind, oh, okay, I really do need to respect this is their human right to data privacy. It's not just a technicality here. And that's why it's important to minimize, to reduce scope, to reduce dissemination later on down the pike. So I would say that's useful to just have as a perspective as you go forward.
That's certainly a valid comment, and it's probably a good theme to round up on. And I think cultural differences aside, it just takes a few data breaches of personal information for people to sit up and take notice. You know, I certainly know that my details are probably in there in the Marriott data breach case. So, you know, I'll be changing some passwords. But I think when people find that their data is compromised, that's when they start to get really concerned about privacy. So I think it will happen in the US at some point as well. Well, thank you so much. Thank you so much for your time. I'm sorry about the technical difficulties.
I did want to step in real quick and just thank Jonathan and Karen for joining us here at EDT Software. And just a quick blurb on Jonathan. He does have his own consulting company there in London, and he specializes in working with lawyers, IT people, and suppliers. He negotiates, he delivers cost-effective solutions, he writes, he speaks, he listens, he hears, he's got humor. So if you need any help over there in the UK for any kind of consulting matters, Jonathan Maas is your guy. And with Karen, I apologize for not getting to your bio prior to the webinar, only because of our technical issues. But Karen is an associate specializing GDPR there at Reed Smith, and her practice involves data privacy and data security, and she does advise clients across jurisdictions regarding cross-border transfer and information governance issues arising in the US and EU. She's advised regarding GDPR compliance. In other words, Karen is very, very qualified for this webinar, so I appreciate your time and your cooperation with us on this webinar, Karen. Thank you very much.
Happy to join.
All right.
Thank you so much. Thank you.
Everyone have a great eDiscovery Day. Happy eDiscovery Day. And we will see you next year. If you're interested in getting a copy of this webinar, it will be available on demand on the Extero site or on the EDT site, which is discoveredt.com. Thank you so much for joining us, and have a wonderful day.
Thank you.
Thank you.